Historical background of Indian constitution and features. Aristotle, the first political scientist in the world, he introduced the empirical observation into the study of politics. Aristotle considered democracy to be the worst form of government. Aristotle is known as the father of political science. His famous book Politics, he elaborated ideas such as ideal state. Cleisthenes is known as the father of democracy. It is a supreme law that determines the relationship among the citizens and its country, and also the relationship among the people and the government. It is a set of written rules that are accepted by all the people living together in a country. There are written certain events in the British rule that laid down the legal framework for organization and functioning of the government and administration in British India. These events are greatly influenced our constitution and polity. They are explained here in chronological order under two major headings: the Company Rule 1773 to 1858, Crown Rule 1858 to 1947. B.C. Rawat, one of the famous historians, categorized the Indian constitutional framework into the following stages: 1600 to 1773, East India Company Rule; 1773 to 1858, Charter Acts; 1858 to 1909, Council Acts; 1809 to 1935, British India Acts; 1947, India Independence Act; 1947 to 1950, Constituent Assembly. So first stage, first stage 1600 to 1773. 1600 to 1773, East India Company Rule. Arrival of the British and the establishment of British East India Company was the outcome of the Portuguese traders Vasco da Gama in 1498, who earned enormous profit by selling their merchandise in India. East India Company was formed in 1599 through the Royal Charter from the Queen Elizabeth I on December 31st, 1680, authorizing it to trade in the East. Subsequently, in 1608 AD, the East India Company sent Captain William Hawkins to the court of Mughal Emperor Jahangir to secure the royal patronage. He succeeded in getting the royal permit for the company to establish its factories at various places on the west coast of India. In 1615 AD, Sir Thomas Roe was sent by the Emperor James I of England to Jahangir's court with a plea for more concession for the company. Roe was very diplomatic and thus successfully secured a royal charter, giving the company freedom to trade in the whole of the Mughal territory. In 1662 AD, when Charles II of England married a Portuguese princess Catherine and received the island of Bombay as a dowry, which he immediately gave to the East India Company in 1668 for £10 per year. The company on the west coast shifted its business headquarters from the Surat to Bombay, Mumbai. In 1639 AD, East India Company obtained the lease of the city of the Madras from the local king, where it built the Fort St. George to protect its factory. Later, Madras was made the South Indian headquarters of the company. The governor of Bengal, Shujauddaulah, in 1651, allowed the East India Company to carry out its trade activities in the Bengal. A factory in the Hooghly was established, and the three villages, Sultanati, Govindpur, and Kolkata, were purchased in 1698 AD by the company to build a factory over there. Subsequently, Fort William was raised in order to provide protection around the factory. It was Mughal Emperor Farooq Siyar which in 1717 AD issued a royal Farman charter granting the company important trading facilities in the Bengal, which included the permission of the export and import of British goods in Bengal without paying the taxes. Granting the company important trading facilities in Bengal, which included the permission of export and import British goods in Bengal without paying taxes. Under the Farman, the company was authorized to issue dastaks, passes for the transportation of goods. In ensuing the East India Company further expanded its base and flourished through it and faced challenges from the Portuguese, Dutch and the French. Major as well as minor conflicts among them often took place from time to time for commercial and political supremacy, but in the end it was the British who proved themselves the most powerful after thrashing the other three and remained in India for more than 200 years as a ruling power. By the 1750s, the East India Company started interfering in the Indian political issues. In 1757, Robert Clive defeated the powers of Nawab of Bengal Sirajuddaulah at the Battle of Plassey, and in 1764, Battle of Buxar was fought between the forces under the command of the British East India Company led by the Hector Munro and combined armies of the Mir Kazim, the Nawab of Bengal, Nawab of Awadh Shujauddaulah, and the Mughal Emperor Shah Alam II, accompanied by Raja Balwant Singh of Kashi. It was a decisive victory for the British East India Company. In 1765, with the Treaty of Allahabad, the Battle of Buxar came to an end. to an end when the company came to an end, and the company which till now had purely trading functions obtained the Diwani rights over revenue and civil justice of Bengal, Bihar, and Orissa. This started its career as a territorial power. In 1772, Warren Hastings introduced the collector system in India to collect the revenue. In 1772, Warren Hastings introduced the collector system in India to collect the revenue. The company rule 1773 to 1858 second stage, 1773 to 1858 Charter Acts, 1773 Regulating Act, 1781 Settlement Act, 1784 Pitt India Act, 1793 Charter Act, 1813 Charter Act, 1833 Charter Act, 1853 Charter Act. So, East India Company was in severe financial crisis and had asked a loan of nearly £1 million from the British government in 1772. Allegations of corruption and nepotism were rampant against the company officials. There was a terrible famine in Bengal where the huge population perished. The dual form of administration instituted by the Robert Clive was complex and drawing a lot of complaints. According to this system, the company had a Diwani rights obtained as a battle of the Buxar in Bengal, and the Nawab has Nizamat rights, judicial and policing functions as secured from the Mughal emperor. In reality, powers were vested with the company. In reality, both the powers were vested with the company. They were vested with the company. The farmers and the general population suffered as their improvement was neglected, and the company was only concerned maximizing their revenue. Lawlessness increased in the Bengal. The defeat of company against the Mysore Hyder Rally in 1769. The company, though earlier chartered, had only been given trading rights by the British Parliament, but slowly, as it started acquiring more and more territory, it started acting like a ruling body. And there in England, the British Parliament could not swallow this situation and put an end to this tendency of the company using the political powers in the name of the trading rights. The company thought it was necessary that these territories should be brought under the control of the Britain. And Regulating Act of 1773. This act has a great constitutional importance. The Regulating Act was introduced by the British Prime Minister Lord Frederick North in the British Parliament in 18th May 1773. The Regulating Act is said to be the first written constitutional law of India. It was first taken up by the British government to regulate the affairs of the East India Company in India. It recognized the first time the political and administrative rights of the company. It laid down the foundations of the central administration in India. Features of this act: it designated a governor of Bengal as the Governor General of the Bengal. Warren Hastings became the first Governor General of Bengal. An executive council was established with 4 members to assist the Governor General of Bengal, and the office of the tenure of each member is for a fixed term of nearly 5 years. It subordinated the governors of Madras and Bombay to the Governor General of Bengal. The Supreme Court was established at Fort William, Calcutta, as an apex court in 1774, comprising of 1 Chief Justice and 3 other judges. The first Chief Justice of Supreme Court was Sir Elijah Impey. Other judges were John Hyde, Robert Chambers, and Caesar Lamister. It prohibited the servants of the company from engaging in private trade. It strengthened the control of the British government over the company by requiring the Court of Directors, the governing body, to report its revenue, civil military affairs in India. Defects of Regulating Act of 1773. Major drawbacks of the Regulating Act of 1773 are stated below. Governor General has no veto power. The major drawbacks of the Regulating Act of 1773 are: the Governor General has no veto power. It did not address the concerns of the Indian population who were paying the revenue to the company. It did not stop the corruption among the company officials. Supreme Court powers were not well defined. Parliamentary control was sought in the activities of the company, proved to be ineffective as there was no mechanism to study the reports sent by the Governor General in Council. Settlement Act of 1781. circumstances that led to the passing act of settlement. A lot of criticisms of administration of Warren Hastings rule. There was a tussle between the Supreme Court and the Supreme Court and the Governor General in Council, which disturbed the balance of administration to a great extent. There was interference in the personal laws of the communities, which has agitated the people. In the year 1777. A complaint was made by the directors of the company against the Supreme Court, as for them it was difficult to run the administration. To address this complaint, the House of Commons appointed a committee known as Turchet Committee to do an inquiry about the administration of the Bengal, Bihar and Odisha. The report of this committee led to the enactment of the Act of Settlement of 1781 to remove the defects of Regulating Act of 1773. This is known as the Declaratory Act of 1781. Objectives of the Act: to remove the ambiguity regarding the few provisions of the Regulating Act and the Charter which has created the division between the court and the government, to support the lawful government of the Bengal, Bihar and Orissa so that the revenue could be collected smoothly, to remove the ambiguity regarding the few provisions of the Regulating Act of the and Charter Act which has created the divisions between the court and the government, to support the lawful government of Bengal, Bihar and Orissa so that the revenue could be collected smoothly, to maintain the protect the laws and customs of the native people. Features of the Act: it exempted the Governor General and the Council from the jurisdiction of the Supreme Court for the acts done by them in the official capacity. Similarly, it exempted the servants of the company from the jurisdiction of the Supreme Court for their official actions. It excluded the revenue matters and the matters arising in the collection of the revenue from the jurisdiction of the Supreme Court. It provided that the Supreme Court was to have the jurisdiction over all the inhabitants of the Calcutta. It also required that the court to administer the personal law of the defendants, that is, Hindus were to be tried according to the Hindu law and Muslims were tried according to the Mohammedan law. That is, court to administer the personal laws of the defendants. It laid down that the appeals from the provincial courts could be taken to the Governor General in Council and not to the Supreme Court. It empowered the Governor General in Council to frame the regulations for the provincial courts and councils. It was the first attempt to separate the executive from the judiciary by defining the respective areas of jurisdiction. Bits in the Act of 1784: to rectify the defects in the Regulating Act of 1774 and Settlement Act of 1781, the British Parliament has passed this Act. It was introduced in the British Parliament by the then Prime Minister William Pitt Jr. Features of the Act 1784: it distinguished between the commercial and political functions of the company. It allowed the Court of Directors to manage the commercial affairs but created a new body called Board of Control to manage the political affairs. Thus, it established a system of double government. The Board of Directors comprised of 6 members. Among them, one is State Secretary. It empowered the Board of Control to supervise and direct all the operations of the civil and military government over the revenues of British possessions in India. It adjusted the council's members from 4 to 3, 1 plus 4 to 1 plus 3. The Governor General was given the right of casting vote. Thus, the Act was significant for the two reasons. The company's territories in India were first time called as British possessions in India. The British government was given the supreme control over the company's affairs in the administration in India. Act of 1786. In 1786, Lord Cornwallis was appointed in the Governor General of Bengal. He placed 2 demands to accept that post. That is, he should be given power to override the decision of his council in special cases. He would also be in the commander-in-chief. Accordingly, the Act of 1786 was enacted to make both the provisions of Charter Act of 1793. It extended the company's trade monopoly in India for another 20 years. The company dividends were allowed to be raised to 10%. The salaries of the staff and the board of control were to be now changed to the company, charged by the company. After all the expenses, the company had to pay the British government £5 lakh British pounds from the Indian revenue annually. The company was granted the authority to grant licenses to the individuals and the company employees to carry on trade in India. This was known as a privilege or a country trade. This led to the shipments of opium to China. It extended the overriding powers given to the Lord Cornwallis over his council to all the future governor generals and governors of presidencies. It gave the governor general more powers and control over the governments of the subordinate presidencies of Bombay and Madras. Governor General's absence from the Bengal, he could appoint the vice president from among the civilian members of his council. So Charter Act of 1813, it extended the company's trade monopoly in India for another 20 years. This act is also known as the East India Company Act of 1813. It abolished the trade monopoly of the company in India. India trade with was open to all the British merchants. However, it continued the monopoly of trade in tea, trade in tea and trade with China. It asserted the sovereignty of the British Crown over the company's territories in India. 1 lakh rupees per annum have been allocated for the spread of education in India through this act. It allowed the Christian missionaries to come to India for the purpose of enlightening the people. It allowed the Christian missionaries to come to India for the purpose of enlightening the people. It provided the spread of Western education among the inhabitants of the British territories in India. It authorized the local governments in India to impose the taxes on the persons. They could also punish the persons for not paying the taxes. The act gave more powers to the courts in India over the European British subjects. It facilitated training to the civil servants. Charter Act of 1833. The Charter Act of 1833 was passed in the British Parliament, which renewed the East India Company Charter for another 20 years. This was also called as Government of India Act of 1833 or Saint Helena Act of 1833. The company's trade links even with China were also closed down. The act permitted the English to settle freely in India. The Governor General of Bengal was redesignated as Governor General of India and vested him all the civil and military powers. Thus, the country's administration was unified and under one control. Lord William Bentinck was the first Governor General of India. It deprived the legislative powers of the governors of Bengal and Bombay, and the Governor General of India was given the legislative powers over entire British India. And the Governor General of India was given the legislative powers over entire British India. The civil and military affairs of the company were controlled by the Governor General in Council. For the first time, the Governor General government was called as Government of India, and the Council was called as Indian Council. With this law, it would increase the number of members of the Governor's Executive Council from 1 plus 3 to 4 and appoint a legal member. As per the Act, the Indian Law Commission was established. The first chairman of the Law Commission was Lord Macaulay. The first independent India's first Law Commission chairman was M.C. Setalwad. The present Law Commission chairman was Justice B.S. Chauhan, 21st Law Commission. The laws made under the previous acts were called as regulations, and the laws made under this act is called as acts. It ended the activities of the East India Company as a commercial body, which became a purely administrative. This fact for the first time introduced a system of open competition for Indians for selection of civil servants. That is, it ended all the activities of the East India Company as a commercial body, while became purely administrative body. This act for the first time introduced an open competition for the Indians for selection of civil servants, but it negated after the opposition from the Court of Directors. East India Company provided Indians with the first opportunity, abolition of racism in the government employment. On the advice of the Raja Ram Mohan Roy, by this law, Lord William Bentinck introduced the English education system in India in 1835 with the help of Lord Macaulay. Charter Act of 1853. This was the last series of the Charter Acts passed by the British Parliament. It was a significant constitutional landmark. The Act did not specify any particular period, unlike the previous charters. This was clear that indication that the company rule could be terminated at any time the Parliament liked. The Act provided the Indian territories will remain under the governance of the company until the Parliament otherwise directed. It separated for the first time the legislative and executive functions of the Governor General's Council. It provided for the addition of 6 new members called legislative councillors to the council. It established a separate Governor General's Legislative Council, which came to be known as Indian Central Legislative Council. Indian Central Legislative Council. This legislative wing of the council functioned as a mini parliament, adopting as the same procedures as the British Parliament. It introduced for the first time the local representation in Indian Central Legislative Council. Of the 6 new members of the Governor Generals in Council, 4 members are appointed by the local provincial governments of Madras, Bombay, Bengal and Agra. Various problems related to the education in India had become one of the key concerns of the British government in 1853. Sir Charles Wood expressed through the dispatch, which expressed that the education in India, education in English as well as the Indian local languages should be enhanced and encouraged throughout the nation. The Wood's dispatch is considered as a Magna Carta of English education in India. It introduced an open competition system of selection and recruitment of civil servants. Accordingly, the Macaulay Committee, the Committee on Indian Civil Service, was appointed in 1854. Initially, these services are known as covenanted civil services. With the time, they came to be known as Indian Civil Services. ICS was replaced by Indian Constitution as All India Services. Warren Hastings laid the foundation of the civil services in India. Lord Cornwallis was known as father of civil services in India. Modern civil services in India was in initiation of Sardar Vallabhbhai Patel, first Indian civil servant Satyendranath Tagore. All India services include IAS, IBS and IFS. IAS Indian Administrative Service, first women IAS Anna Raja Malhotra George. IPS Kiran Bedi was the first woman to join the Indian Police Service and who was instrumental in introducing the prison reforms in India. IFS Indian Forest Service in 1963. Indian Forest Service was created and it came to existence in 1966. The number of board of directors was reduced from 24 to 18. The number of board of directors was reduced. The number of board of directors was reduced from 24 to 18, out of which 6 people were to be nominated by the British Crown. The Law Commission constituted various commissioners to make the legal laws and formulated the following laws: CPC, Civil Procedure Code 1859, IPC, Indian Penal Code 1860, CRPC, Criminal Procedure Code 1861. The Crown Rule 1858 to 1947. Since the 1858, the constitutional reforms made by the King or Queen directly after assuming the power are known as Government of India Acts or Council Acts. Government of India Act of 1858. The significant act was enacted in the wake of the revolt of 1857, also known as the First War of Independence or the Sepoy Mutiny. The act known as the Act of Good Government of India. The Good Governance Day is observed in India annually on 25th December, the birth anniversary of the former Prime Minister Atal Bihari Vajpayee. It was established in 2014. V.D. Savarkar described the Sepoy Mutiny. V.D. Savarkar described Act of Good Government of India. V.D. Savarkar described the Sepoy Mutiny of the Meerut, 18th May 1857, as the first war of independence. This act abolished the East India Company and transferred the power of government, territories and revenues to the British Crown. It is provided that the India to be governed directly in the name of the Crown. The representative of the British government in India was the Governor General and the Viceroy, both the same person to avoid the conflicts. The first Governor General and the Viceroy of India is known as Lord Canning. The Viceroy and the governors of the various presidencies were appointed by the Crown. The Viceroy was to be assisted with an executive. Council. Viceroy was to be assisted with an executive council. The act abolished the dual government that was introduced by the Pitt India Act of 1784. The principle of doctrine of lapse was withdrawn. Liberty was given to 560 Indian rulers subject to the British, and it also opened the doors, some of the doors for the Indians in the government services. It created a new office, Secretary of State, vested with completely authority and control over the Indian administration. The Secretary of State was a member of the British Cabinet and was responsible ultimately to the British Parliament. The first Secretary of State was Sir Charles Wood or Lord Stanley. The powers of the company's court of directors were vested with the Secretary of State for India. It established a 15-member Council of India to assist the Secretary of State. The council was an advisory body. The Secretary of State was made as chairman of the council. Indian Councils Act of 1861. The Indian Councils Act of 1861 was passed by the British Parliament on 1st August 1861 to make the substantial changes in the composition of the Governor General's Council for an executive and the legislative purposes. The most significant features of this act was association of Indians for the legislative work. This act introduced the legislative councils in states for the first time in India. It was the first instance in which the portfolio system of Council of Governors, Council of Governor General was incorporated. The budget system was introduced in 1860. For the reasons for the enactment of Indian Councils Act of 1861. India was governed by the England through the Government of India Act of 1858. However, it did not alter any substantial way of system of government that prevailed in India. Aftermath of mutiny of 1857, there was a general perception in England that it would be very difficult to secure the government in India without the cooperation of Indians in administration. The Charter Act of 1833 had deprived the governments of Madras and Bombay. Their power of legislation system came out to be defective and failure to frame the laws for the locals. There was a need for giving provinces power to make laws for themselves or for their locals. So Features of this act. Features of this act. For the executive functions of the council, fifth member was added. Now there was five members for whom for the executive functions of the council, fifth member was added. Now there were five members for home, military, law, revenue and finance. As a sixth member for public works added in 1874. For legislative purpose, a provision was made for an addition of 6 to 12 members to the central executive. At least half of the additional members to be non-officials. These members were nominated by the Viceroy for a period of 2 years. Lord Canning, the Governor General and the Viceroy at that time introduced the portfolio system. This system, each member was assigned a portfolio for a particular department in 1859. This system, each member was assigned a particular portfolio in the particular department in 1859. Lord Canning nominated the three Indians to the council in 1862, namely Raja of Benares, the Raja of Benares. That is, Lord Canning nominated three Indians to the council in 1862, namely Raja of Benares, Maharaja of Patiala, and Sir Dinkar Rao. The Legislative Council has a limited role. It was chiefly advisory. No discussion on finance was permitted. Even though Indians were nominated, there was no statutory provisions for the inclusion of Indians in it. It allowed for the decentralization of administration with vesting of legislative power in the presidencies of Bengal, Bombay and Madras. The power of ordinance was given to the Governor General, gave him the absolute powers. Indian High Courts Act of 1861. The High Courts Bill was moved by the Secretary of State, Sir Charles Wood, on 6th June 1861 and was passed on August 1861. The Indian High Courts Act 1861 abolished the Supreme Court and the Sadar Adalats in the presidencies, and the act also empowered the crowns to issue letters patent under Great Seal of United Kingdom, to erect and establish the High Court of Judicature at Calcutta, Madras and Bombay. The Charter Act of High Court of Calcutta was ordered in May 1862, and Madras and Bombay were issued in June 1862, thereby making the Calcutta High Court the first court of the country and the oldest High Court in India, and the biggest first High Court after the country, and the oldest High Court in India and the biggest High Court in India is Allahabad High Court. As per the Act, Allahabad High Court was established on 17th March 1866. Currently in India, there are 25 High Courts established in different states of the country. Andhra Pradesh is the recent state to have the High Court and established in Andhra Pradesh 1st January 2019. High Court was established in Andhra Pradesh in 1st January 2019. The Criminal Procedure Code 1861 was passed by the British Parliament. CRPC was created for the first time ever in 1882 and amended in 1898. Indian Councils Act of 1892. It was an act of British Parliament that increased the size of the legislative councils in India. The act was an important milestone that led to the establishment of the parliamentary form of government at a larger stage. Reasons for the enactment of Indian Council Act of 1892. A.O. Hume founded the Indian National Congress on December 28, 1888 at Gokuldas Tejpal Sanskrit School in Bombay. A.O. Hume founded the Indian National Congress on December 28, 1885 at Gokuldas Tejpal Sanskrit School, Bombay. Lord Daprin, a British Governor General during the founding of Indian National Congress. Its first meeting was attended by 72 delegates. The first president was Umesh Chandra Banerjee. The establishment of Indian National Congress 1885 encouraged the feeling of nationalism, and this led to the INC to put forth some of the demands like reforms in the legislative councils, principle of election instead of nomination, right to hold the discussions on financial matters, etc. to the British authorities. Features or provisions of the Indian Councils Act of 1892. The Act provided for the additional members in the central as well as provincial legislative councils. By this law, number of non-executive members in the central legislative council should not be less than 8, not be less than 10 and more than 16, and not less than 8 and more than 20. In the state legislatures, the power of legislative councils was increased. Members could now discuss the budget without right to vote in it. They were also not allowed to ask supplementary questions. The first budget was formally introduced in India in 1860 by Sir James Wilson during the Viceroy General of Lord Canning. They could ask questions on the domestic matters with prior permission of the Governor General. They also asked to ask questions on the public interest. The Governor General in Council was empowered to make rules for nominations of members. The Governor General in Council was empowered to make rules for the nomination of the members subject to the approval of State Secretary of State for India. The railway budget in India was separated from the general budget in 1921 on the recommendations of the Accord Committee. During the financial year 2017-18, railway budget was merged into the general budget as per the recommendations of the Bibek Debroy Committee. A system of indirect elections was introduced to elect the members of central and provincial legislative councils. Gopalakrishna Gokhale, Firoz Shah Mehta, Surendranath Banerjee, Gopalakrishna Gokhale, Surendranath Banerjee, Firoz Shah Mehta, Bilgrami, Hussain Bilgrami, Dadabhai Naoroji, and Rasbihari Ghosh were nominated to the council. The first Indian who elected for the British Parliament was Dadabhai Naoroji in 1892. The universities, district boards, municipalities, zamindars, and chambers of commerce were empowered to recommend the members to provincial councils. Functions of the provincial legislative councils were enlarged, and they were empowered to make new laws. The functions of the provincial legislative councils were enlarged, and they were empowered to make laws or repeal the old ones with prior permission of the Governor General. The Governor General was empowered to fill the seat in case of central legislature and the Governor in case of provincial legislature. In 1905, Lord Curzon divided the Bengal. Vande Mataram movement and the Swadeshi movement were against the partition of Bengal. The Muslim League was founded in 1906 by the brother of Nawab Samiullah Ali of Dhaka. In 1907, Indian National Congress split into extremist and moderates at Surat.